Good morning, everyone, and welcome to today's webinar on planning concerns and liabilities in residential property transactions. My name is Danielle, and in the next 30 to 45 minutes, we're going to be taking a closer look at planning and various concerns and challenges, looking at basement extensions affecting particularly the London area, amongst other things. A copy of the slides will be made available to you at the end of the presentation, and if requested, we can provide a recording of the webinar. You should see a panel on your screen which allows you to ask written questions, so please feel free to submit any questions as we go, and I will try and answer these at the end of the webinar. If you're using a Windows PC or Mac, you should see that there are product cards visible in the control panel if you click on the handout. The file will start to download for you. There'll be a quick feedback survey at the end of the webinar, and we're always looking at ways of improving our presentations for future. I'd really appreciate it if you could take a few seconds to answer some questions at the very end. Now let's get started. So this presentation will help provide a better understanding on the value and purpose of ordering dedicated planning searches in addition to your current standard conveyancing searches. We're going to cover legislation. We're going to have a quick look at some basement extensions, particularly in the London area, and the challenges they provide. We're going to have a quick look at potential impacts of Brexit and some case studies and what the differences are between a dedicated planning search and a local authority search. So what you see on the screen, this table shows you the number of planning applications received versus planning applications granted in the last few years. It is worth noting that these figures are for England only. So the number of applications is fairly consistent, hovering between 400,000 and 500,000, and the granted applications are all below 400,000. So Brexit, it's been on the lips and thoughts of everybody in, of course, the last 6 to 12 months. What are the impacts that Brexit could have on planning? So has UK planning law and practice been affected by the EU? Well, yes, it has to some extent. The main influence of EU law on planning in the UK is in relation to the requirements for the environmental assessment of development projects and policies. There are three key EU directives, namely the Environmental Impact Assessment Directive 2011, the Strategic Environmental Assessment Directive 2001, and the Habitats Directive 1992. These directives have been transposed into UK legislation primarily by way of the Town and Country Planning Regulations 2011, the Environmental Assessment and Plans and Programs Regulations 2004, and Conservation of Habitats and Species Regulations 2010. So how will the EU directives and the regulations be affected by Brexit? If the UK seeks to remain a member of the EEA and the EFTA in an approach similar to that taken by Norway, it is likely that it will be required to comply with most European legislation. So for instance, EEA members are required to comply with the EIA and SEA directives, but are not required to comply with the Habitats Directive. In the event that the UK seeks to remain only a member of the EFTA in an approach similar to that taken by Switzerland, there will likely be more scope for flexibility. Alternately, if the UK chooses to operate outside of these regimes and/or forges a bespoke relationship with the EU following Brexit, it is possible that the EU directives will cease to influence UK law. Notwithstanding the transposition of the EU directives into UK law through the regulations, it is anticipated that Parliament would need to take positive action to maintain the status of the regulations following Brexit. Therefore, there is a possibility that the regulations could lapse following Brexit. There are, however, other factors in play which make it likely that the government will seek to maintain a requirement for environmental assessment as part of the UK planning system. In particular, the UK's international treaty obligations will continue after Brexit and include the Convention on Access to Information, public participation in decision-making, and access to justice in environmental affairs, which requires public participation in environmental decision-making and access to environmental information. These obligations are, at least in part, met through the provisions of the EIA regulations and the SEA regulations. So are there any implications for national planning policies? Now this depends on the Brexit terms reached within the EU, and it is possible that national and local planning policies will need to be reviewed and amended. Are there any other likely impacts of Brexit on the property or planning sectors? Other than the legal impacts to the UK planning system described previously, Brexit is likely to affect the property sector more generally. Now, market commentators in the property sector have indicated that there is likely to be a fall in property prices and at least a short-term downturn in development and construction. The number of planning applications submitted may reduce, and UK infrastructure planning may see decreased activity as a result of the loss of EU infrastructure project funding. As property prices fall, people are less likely to be able to afford to move, which could lead to an increase in extensions to existing property, and this could include more dig-down basements in areas where space is restricted. So we're going to take a look at a few examples on the next few slides. Now, we are increasingly seeing existing properties, new developments, and infrastructure sitting side by side in what seems like ever more congested spaces, particularly in the London area. Now, developments to many are a plague. To others, they are an opportunity, but whether they're big or small, they are always controversial. Now, figures from construction insight firm Glenigan report that there were 887 applications to build a basement on residential property in London in 2015. This was up a quarter compared with 2014 and almost double the pre-crisis peak in 2007. We can see this figure increased further still to 1,002 applications in 2016. The rise of the multi-story or iceberg basements, some with cinemas, swimming pools, and bowling alleys, have seen various media-profiled cases with various individuals, such as Rachel Johnson, who was opposing an iceberg basement near her Notting Hill home, Brian May, the lead guitarist of Queen, who's co-founded campaigns to ban homeowners from digging basement homes. And even the French government has actually gotten involved, attempting to fight off the ambitions of the super rich to extend their properties. John Hunt of Foxtons fame, building a mega basement museum for his vintage car collection next to the French embassy. But are all basements so bad? Basement extensions can cost, on average, £500 to £600 per square foot in areas such as Kensington and Chelsea. This puts the average basement extension cost at £250,000. Given the average Greater London property price has been recently put at £616,000 and 160 in January this year, according to Rightmove, this shows it is clearly cheaper than moving house in many instances. So far in 2017, we've seen more than 200 basement extension planning applications alone. With all these applications and greater congestion, this is ultimately leading to a greater number of disputes over space. Therefore, basement extensions have become for some a hot issue across central London as homeowners who are unable to buy larger houses dig down to extend their living space, often to the consternation of their neighbors. So on the screen, we can see a picture of a case where a forthcoming legal challenge centers on a long-running dispute in a small street of Victorian cottages in Kentish Town, which will most likely set a precedent for would-be basement diggers who want to take advantage of the so-called permitted development rules to avoid going through the planning process. Now, Michael Etherly, one of the residents in the street, challenged Camden Council for allowing one of his neighbors to build a basement extension under permitted development rights. In December 2016, the High Court ruled in favor of Mr. Etherly and found that the council was wrong to grant a certificate of lawful development for the proposal. The ruling is likely to have implications for other dig downs, as it will require local authorities to consider the engineering aspects of an extension separately from the main development plan, and so means many basement proposals are likely to require planning permission. Any basement which requires engineering or excavation work should have formal planning permission, and councils through this approach, of course, have more control in setting strict limits on, for example, the operational time of works or the number of lorries used to take away excavated soil, etc., etc. So why order a planning search? Now, there are quite a few reasons as to why a planning search is recommended, which you can see on the screen. You or your client could be buying or selling property with no knowledge of how views could be altered or removed due to new development. Have the neighbors ever attempted to obtain planning permission for new build development? Are they trying to achieve permission for a basement or an extension? Are those fields that you can see from your house safe from development? And why are the vendors selling in the first place? All of these questions we perhaps don't ask enough when looking to buy property. Large-scale developments are not always identified in the suite of mandatory searches, such as the CON 29 local authority search, and may only be picked up by specialist companies. Now, there's two recent cases that I'll touch on in the next few slides. One of them is, of course, the Bird and Bird case, which has been in the media as of late. So in this case, leading solicitors Bird and Bird were found liable in the High Court for a £2 million breach of duty after failing to advise their client of a major development close to her £25 million London property. Ms. Chow had paid a $2.5 million deposit on the 7-bedroom property in NW8, and her solicitor had undertaken a planning search which disclosed the plans for a new academy school housing 1,400 pupils and a whopping 6 stories high, yet failed to mention the matter in their report in title, presumably due to the distance from the property, which was a mere 91 meters. Not only do large-scale developments such as this have a negative impact on the aesthetics of a property, there are other lasting effects such as increased noise and air pollution as well as traffic. The court found that Bird and Bird had a clear duty of care to Ms. Chow to advise on the contents of the planning report that was obtained, which highlighted the presence of this planning application. It was argued that Bird and Bird should have stressed the negative impact given the property's intended use ahead of the purchase and that this represented a clear breach of duty. His Honor, Judge Mark Pelling, QC, said it was a breach of duty to say, as was said, that the information provided did not reveal anything that adversely affects the property. In another recent case of Thorpe and Another versus Abbott and Another, the High Court has dismissed a claim of misrepresentation where it was alleged that the sellers of the property had given fraudulent replies in the seller's property information form. An inaccurate pre-contract statement, whether made in reply to pre-contract inquiries or not, may entitle the buyer to bring a claim for misrepresentation or negligent misstatement. The misrepresentation may be fraudulent, negligent, or innocent, depending on the seller's state of knowledge at the time of the representation. Let's go over the quick facts. In 2010, the Abbotts sold their house to the Thorpes for £625,000. After the purchase, the Thorpes were made aware of proposals for large-scale developments in the area. These proposals dated back to before the purchase, when the property was still owned by the Abbotts, although these proposals were not set in stone at this stage. The Abbotts were aware of the planned development, having attended public meetings regarding the development. They had also signed a petition against it and discussions about the proposals with nearby residents and had received communications through the post regarding the events. In this case, the questions which resulted in the alleged misrepresentation were: Notice 3.1, has the seller either sent or received any communications or notices which in any way affect the property? If yes, please supply a copy. 3.2, has the seller had any negotiations or discussions with any neighbors or any local or other authority affecting the property in any way? If yes, please give details. Now, the seller answered no to both questions. A few months after the purchase was completed, the buyer commenced legal proceedings against the seller for damages for fraudulent misrepresentation. The claimant stated that if the seller had answered the SPIF truthfully, their replies would have revealed proposals for the nearby development and they would have withdrawn from the purchase. Now, the court ruled in favor of the defendant, holding that the seller's answers were not misrepresentations. The judge stated that the words communication and affecting used in the questions should be given a relatively confined interpretation in favor of the seller. The judge then further argued his ruling on the starting point in a conveyancing transaction is still a caveat emptor, and the questions on the SPIF are intended to be capable to be answered by a lay person. and should not be interpreted in such a way that expert advice would be needed to understand the information required. So there are two distinct and important conclusions to draw from these high-profile cases. The first being, as I've mentioned earlier, that all purchasers should be aware of the first rule of conveyancing transaction, which is to employ a caveat emptor, especially if sellers are not disclosing information and shouldn't assume that they will. And you should also undertake your own independent inquiries. The second is to ensure that you and your client should read the reports ordered and discuss any potential issues with your solicitor or the search provider. Now, what you see on the screen is an example of a ground share planning search for a property in Blackburn, where there are two large developments proposed. Both are for residential developments with associated works to include sewer systems, landscaping, infrastructure, and roads. What was once fields and a nursery will soon be a large housing development. This information would not be picked up in a standard local authority search, which only includes applications for the property in question. Now, the couple living in the property circled red were unaware of plans for a mini town that is set to encompass their detached cottage, currently situated within miles of fields in Chippenham, until a passerby mentioned the project. It turns out the couple were not consulted when developers first applied for planning permission, and their £425,000 home didn't even appear on the submitted aerial drawings, despite being in the middle of the proposed new development. Needless to say, there's always a bit of a mixed reaction when it comes to new developments, as you can see here. Land at junction of Stone Pit Lane and West End Lane, Henfield, West Sussex, where major local backlash happened. This was a development of 160 residential dwellings together with associated landscaping, open spaces, and access. And as you can see, the locals weren't too happy about it. So now let's move on to some legislation. If a development or property is constructed without the appropriate planning permission, it's worth bearing in mind that the development can become lawful after a certain period of time via the lawful development certificate. Now, if you want to be certain that the existing use of a building is lawful for planning purposes, or that your proposal does not require planning permission, you can apply for a lawful development certificate. It is not compulsory to have an LDC, but there may be times when you need one to confirm that the use, operation, or activity named in it is lawful for planning control purposes. So under the Planning and Compensation Act 1991, you've got rolling time limits of 4 and 10 years. 4 years for building, engineering, mining, or other operations. 4 years for change of use of a building or part of or to a single dwelling, and 10 years for all other development. So once these time limits have passed, the development becomes lawful in terms of planning. Now, the Community Infrastructure Levy came into force in April 2010. It allows local authorities in England and Wales to raise funds from developers undertaking new building projects in their area. The money can be used to fund a wide range of infrastructure that is needed as a result of development. This includes new or safer road schemes, flood defenses, schools, hospitals, and other health and social care facilities, park improvements, green spaces, and leisure centres. The charging authorities in England will be district and metropolitan district councils, London Borough Councils, unitary authorities, national park authorities, the Broads Authority, and the Mayor of London. In Wales, the county and country borough councils and the national park authorities will have the power to charge the levy. These bodies all prepare development plans for their areas, which are informed by assessments of the infrastructure needs for which the levy may be collected. The government has decided that this tariff-based approach provides the best framework to fund new infrastructure to unlock land for growth. The Community Infrastructure Levy is fairer, faster, and more certain and transparent than the system of planning obligations, which causes delay as a result of lengthy negotiations. Levy rates will be set in consultation with local communities and developers and will provide developers with much more certainty upfront about how much money they will be expected to contribute. Under the system of planning obligations, only 6% of all planning permissions brought any contribution to the cost of supporting infrastructure, when even small developments can create a need for new services. The levy creates a fairer system, with all but the smallest building projects making a contribution towards additional infrastructure that is needed as a result of their development. So how much will the levy raise? The introduction of the levy has the potential to raise an estimated additional £1 billion a year of funding for local infrastructure by 2016. The levy will make a significant contribution to infrastructure provision. The levy is intended to fill the funding gaps that remain once existing sources have been taken into account. Local authorities will be able to look across their full range of funding streams and decide how best to deliver their infrastructure priorities, including how to utilize monies from the levy. This flexibility to mix funding sources at a local level will enable local authorities to be more efficient in delivering the outcomes that local communities want. Now let's have a quick look at the Neighbourhood Planning Bill. The government hopes that the measures in this bill will support more house building and provide more local say over the development. It seeks to speed up and strengthen the neighbourhood planning process by simplifying how plans can be revised as local circumstances change. Additionally, it is expected that the bill will make sure that plans come into force sooner after being approved by local people. The bill seeks to ensure that planning conditions that require developers to take action before work starts are only used when strictly necessary, but in a way that makes sure heritage and environmental safeguards remain in place by inserting a new section into the Town and Country Planning Act 1990. An explanatory note released alongside the legislation states that planning permission can't be granted subject to a pre-commencement condition without the written agreement of the applicant to the terms of the condition. The Secretary of State will be provided with the power to make regulations about what kind of conditions may or may not be imposed on a grant of planning permissions and in what circumstances. Now, this bill has received royal assent as of April 27, 2017. Should you require more information on anything I've spoken about today or any of the legislation, please do let us know and we can point you in the right direction. Now, GroundSure have recently launched a planning alert which flags up the need for a planning report when purchasing your standard environmental searches. As you can see on the screen, we will flag up a planning report if we find the following. Within 75 meters, extensions or home improvements on a single dwelling. Within 100 meters for urban and 250 meters for rural, a small residential development of 1 or 2 new dwellings. Within 150 meters for urban and 250 meters for rural, a medium development, mainly residential, of 3 to 9 dwellings. And 250 for urban and 500 meters for rural for a large development, mainly residential, of 10 or more dwellings, a small non-residential and mixed-use land project under £250,000 build cost, a large non-residential project over £250,000 build cost, and a mega non-residential project over £200 million build cost. So why would you choose a GroundSure planning report? We have a large search radii to ensure relevant applications can be captured, and we provide up-to-date planning statuses. We actually collect data not just once a day, but actually several times a day from the various planning sources that we have. We provide information on house extensions, new builds, small and large projects. And I'm going to show you what some of the reports data sets are in the next few slides. So on the front page, as you can see here, the report is really easy to understand with a number of planning applications and what categories they fall under, all broken down on the front page of the report. All of the definitions are also provided. We also provide details on the local area information, as you can see here. So transport links, nightclubs, attraction, eating, dining, the usual neighborhood things that you would want to know. And here we provide a very clear indication of any potential developmental constraints. So when I talk about developmental constraints, it could be anything from areas of outstanding natural beauty, sites of special scientific interest, ancient woodlands, special protection areas, and a few more things that you see on the screen. In terms of education and crime, education covers nursery all the way up to colleges and universities. For Key Stage 2 and above, we provide the Ofsted ratings and exam success. One thing to note is that the education data is for the previous school year. So by the end of this year in 2017, we will have the data for 2016. Schools may be inspected at other times during the year, but because the information is housed centrally, it can only be updated once a year. Within the education section, we provide the 5 closest schools to the property within 30 kilometers. Crime information is sourced from data published by the Home Office, who in turn receive data from the 43 geographical police forces in England and Wales, the British Transport Police, and the Ministry of Justice. We have also recently launched a new all-in-one report called Avista, which covers, among other things, contaminated land, full flood, ground stability, radon, transportation including HS2, Crossrail 1 and Network Rail, energy, and of course planning. If you would like a single, clear and concise report that provides your client with easy to understand next steps and recommendations, the Avista report will meet all the guidance and requirements of the Law Practice Society note on contaminated land and flood, plus we provide relevant planning information and then some. The main difference between the ground shore planning report, which I've shown you earlier, and the planning report that sits within Avista are 2 main differences. So Avista interrogates the same data sets as ground shore planning, but it excludes local amenities and education. And the second difference is Avista uses the data and definitions from the Office of National Statistics for rural, mega-urban, and urban locations. And it then, once it understands which location it's in, so if the property is in a rural or urban or mega-urban location, it then adjusts the search radius accordingly for planning based on those definitions. So therefore producing much more relevant results for the property of your client. So as an example, if you are in central London or a large city or mega urban location, you wouldn't want a 500-meter search radius on anything because then you're just going to get thousands and thousands of planning applications. So what the Avista report does is actually automatically shrinks or expands those search radiuses based on the definitions given to us by the National Statistics Office. So it's actually a really, really intelligent way of doing a planning report, which provides much more relevant information for you and the client. Either way, I hope that I've been able to convey the importance of planning and how it can benefit you and your clients. And that brings us to the end of today's webinar. Many thanks for your time, and I hope you found today's session useful. Please do let me know should you require any further details or have any questions. The feedback survey will launch shortly, and we'd really appreciate it if you could take a few seconds to fill it out. Many, many thanks, and have a wonderful day.